Good evening, GAE members, and thank you for joining me this afternoon for the first of what is going to be a series of webinars. We are calling them Rights at Night because we are going to be providing you information about your legal rights and your other rights as we move through the year. Tonight, our first topic is free speech, social media, and privacy and virtual instruction. So thank you for joining us this evening. If you have a question during the presentation, please send your question through the chat to me, Lisa Morgan, and then after the presentation, we have some of the questions already out, and then if you have an additional question, we will make sure we have time to get all your questions answered this evening. So at this point, I will turn it over to our legal counsel, Mike McGonigal, to talk about our rights for free speech and social media.
Thank you, President Morgan. Can you see it? Run show?
Yep.
There we go. So can I get rid of it? No. Okay. All right. So just a quick reminder of who we are as GAE members. We're the faces on the front line. Our organization is open to all school employees, from the superintendent to the principal to classified staff, school bus drivers. And we exist to support, protect, and strengthen school children in the public education setting only. I want to plug legal services while I have a captive audience. We have employment liability insurance, which is there as a protection in the event that, say, for example, a parent sues the school district on behalf of one of their students. So you have liability protection of $1 million, but moreover, it exceeds that to $3 million, which is more than other organizations. And we have you covered for up to $9 million for attorney's fees in any combination of lawsuits. And also that is more than any competitor organization. And the other important thing to help us sell membership, increase membership, is to point out that GA Legal Services does not have a predetermined cap on the amount of legal fees and costs that we expend in defense of a member, unlike other organizations. And we also file affirmative lawsuits, and we will get into a few of those this evening. Other organizations do not, they don't cover this. And as we'll see, affirmative lawsuits, in my experience, you begin counting at maybe $25,000, $50,000 onwards up into the six figures sometimes. And I don't know about you, but I certainly don't have $50,000 for a lawsuit. So that is a true value for your membership money. So we want to go over your rights regarding free speech. And this is where your rights are created at both the federal, state, Department of Education, Professional Standards Commission for those who possess teaching licenses, and most importantly, local Board of Education policy. The folks that we elect are those that create rights, your rights. They aren't created out of thin air. They're almost all of them are from statutes, federal, state, and local Board of Education policy. So it's very important that we all become politically involved. And part of that is understanding what your free speech rights are in organizing context, as well as gaining confidence that GAE will have your back when you decide to step up as a local affiliate or use your status as a local association president and speak up and speak loudly about matters that are important for membership. So you need to know what your policies are, and in tonight's discussion, you will need to your homework is go to your school district's website and look for the employee speech policy, your social media policy, and if you don't have a social media policy, you might look for something called an acceptable use policy that really is designed years ago before social media became prominent, and it explains the do's and don'ts of using the school district's computer for school use. And the first tip I'd say for the evening is never use the school district's computer for your personal business. It's only to be used for business purposes. And think about when you click send, that whatever you send on the school district's computer could potentially be tomorrow's headline, because that's all subject to the Georgia Open Records Act. So we'll start diving into sort of the contours of freedom of speech governed by our national federal constitution as well as the Georgia state constitution. And we have to start off with saying, you know, there are limitations. Free speech as public employees, right? Our members are public employees. It's not an absolute right. And it just doesn't give us the right to say whatever we want, when we want, and to whomever we want. You know, we'll explore the contours and limitations of free speech and association rights. And of course, other freedoms covered in the First Amendment are freedom from religion and the separation, I should say, or of church and state. And so what that means for us is we can't proselytize our personal religious beliefs to the classroom as a captive audience. We're prohibited from doing that because government cannot favor one religion over another. That's pretty basic, everybody knows. Freedom of the press, that gets into some of what we'll talk about tonight as we explore reopening plans, for example, and virtual learning, and how we can contact the press about what is really happening in the classroom today. Freedom of association, that's the very heart of GA's existence. We have a right to associate with whomever we wish to in this society. It doesn't matter either on an individual level, no matter your race, color, and creed. And if we wish to come together as a membership, as a dues-paying organization, that is the cornerstone of our rights as citizens. And that will dovetail into your free speech rights, speaking as a citizen as well as an association member or an association leader. And the last one I'll just touch on is also mentioned in the Constitution is your right to petition the government. So what that can also mean is we can or you can sign community-led petitions. Community-led petitions, and I've written these in years past that are critical of the school district. And that can be about matters of policy, or you just don't like the direction the superintendent is taking. And so what we've done is utilize our relationships with community groups and let them take the lead, and our members can sign as private citizens on to be critical of the school board, for example. So that's another one of our First Amendment rights. So now getting a little bit closer to the meat of tonight is the first bullet point expresses in a highly condensed form, a couple hundred years of free speech rights as developed through our court system. And so, and I'll read it, I don't like reading from it, but the First Amendment protects speech of public employees only to the extent they are speaking as private citizens on matters of public concern. So right away, you can see in your day-to-day activities as a public school employee, how is it possible for you to express an opinion as a private citizen? And it's, I mean, just got to be honest, it's virtually impossible to do so. And that's why we'll emphasize as we go through tonight that you have greater rights on your own time, utilizing your other statuses. You're speaking on, say, Facebook. It'd be important to layer in you're speaking as a citizen, a taxpayer, a voter. What about your status as a parent, a grandparent, an aunt, or an uncle? If you have children enrolled in the local public school system, you need to take the focus off your status to the extent you can as you're speaking as an employee, and use your local association. We need to see more of this happening around the state, and we are, but we need to be more robust in that effort, because most of your rights are created at the local Board of Education level. And we'll see in another series down the road in November that there are laws on the books that allow your school districts to actually waive many of your educational rights. And they can be changed, but that can only happen through political organization and political speech directed squarely at your local Board of Education. And the best way to do that is, if you're a member, it's not necessary for you to do it on your own. That's why we exist, GAE, as well as your local associations. And you have stronger protections if you exercise your free speech rights to criticize your employer if you speak through your association. So get into some of the legalities. We'll see that your speech as a public employee is not protected, and this is the list that's generally recognized in the country. If you're speaking within your job duties, and there's a famous 2006 Supreme Court case, Garcetti, and here's what Garcetti was about. He was an assistant district attorney out in California in Los Angeles, and he was blowing the whistle on a ticket fixing scheme by the local police department, and he was fired from his job for reporting that illegal activity to his superiors in Los Angeles. And so the case went up to the U.S. Supreme Court, and the case started probably in 2004, and you can see it took 4 years through litigation and the appeals process to reach up to the Supreme Court. And the Supreme Court in 2006 came out with a remarkably harmful decision in the context of public employee speech. What they basically said was this public employee had a duty to report illegal activities. And therefore, they created this rule that because it was within his job duties to report that, he could be fired for that. And you cannot look to the U.S. Constitution for any remedy, whatever the remedies you're seeking. They said you would have to look to your state constitution and your state whistleblower laws, if they exist in your state, and we do have one here in Georgia. But it was a remarkable setback for public employee free speech rights in our country. Just another example of who we elect, in this case to the presidency and the U.S. Senate, is going to have a deep generation after generation impact on our rights. So the next case you'd highlight, and you can look for this online, Hubbard, that's former President Jeff Hubbard. And when Jeff was the president of GAE, he was on loan from the Clayton County School Board. And that was the time, folks who have a memory about this, that the Clayton County Board of Education was in some trouble with the state accrediting agency, right? I believe for micromanaging. The school board members were micromanaging, not staying in their governance lane. Okay, so Jeff spoke up publicly about that, and he was critical of the Clayton County Board of Education. Well, they turned around and said, Jeff, you can't be critical of Clayton County schools. And so they terminated his on-loan agreement with GAE. So the question, and we filed a lawsuit on this point, arguing that President Hubbard had a First Amendment right to speak up and speak out against Clayton County schools on matters of public concern. And we, it's remarkable, we lost at the trial court level. The trial court completely botched the decision. And so we appealed it on up to the 11th Circuit. At any rate, it clarifies the distinction of speaking as a public, as a private citizen. In this context, Jeff was speaking as a private citizen, not as an employee of Clayton County, and they got it right on appeal. So take it, if you have a minute, it's a great decision. It's the first of its kind in the country. NEA supported us in that, and it is now law in the 11th Circuit and can be cited around the country, protecting other NEA state presidents to speak up against their own school district. So, and also, so your speech would not be protected if it deals with private personnel matters. So if I'm upset, Mike's upset with his evaluation, and he goes into the principal's office, and this comes out of a real federal case, and Mike's having a heated or professionally heated discussion with the principal, and Mike tears up his evaluation, slaps it down, and just leaves. That would be a personnel matter. And that question was litigated a number of years ago. It wasn't our case, but the educator got fired, and one of the reasons stated was her conduct in this meeting with her principal. And the court ruled, well, that conduct dealt with a private personnel matter, and so her speech in that meeting on the school's time, unprofessional, maybe debatable in the context, but they said she did not have First Amendment rights or didn't have remedies, for her particular claim. And then we'll also see where when we speak publicly, even if it's a matter of public concern, say the reopening and the lack thereof and all the chaos there, if it causes a disruption in the workplace, the courts say, even if you're speaking on a matter of public concern, we want to reduce class sizes, we want a pay increase, things like that. The courts still can find an out that under the disruption to the efficient, smooth working of the school. But that's the general layout of what some of the limitations are. The Atwater case, I put that one up, and I won't, what I'll get into is Atwater was superintendent of Tift County Schools, and Ms. Tucker was a middle school teacher. This is not a GAE case, but she posted on Facebook items that went viral, and she was expressing her views of Black Lives Matter parade in Tifton, and that might have been okay. But then she went on to, and I won't repeat it, you can look it up for yourself through this citation, the derogatory terms in which she was describing the Black Lives Matters protesters. and really was very colorful is the only way I'll describe it, but you can look it up for yourself and you can read what was posted. And the lesson would be there is that you have to put yourself in the place of one of her students. If you're a Black student, African-American student in your classroom, and you read what she had posted, which went viral, pretty good chance that that's going to cause a disruption in the workplace. Very good chance. So she may have been speaking on a matter of public concern, but clearly it did cause a huge disruption in the local Tifton community. And then finally, obviously, you don't have any First Amendment rights or remedies if what you say publicly is unlawful or untrue, or defamation is just an assertion of a false fact. You can say, well, Mike McGonigal, in my opinion, is not a great lawyer. Okay, fine. You cannot say Mike McGonigal has a criminal record for child molestation, because I could prove that's not the case. So that's an example of unlawful defamatory speech. So we can get into some of the questions here, and we'll have others beyond these 5, but looking at some of the rules that we have briefly gone through, we can start to talk about some of the questions. Are the following protected, not protected speech? So, for example, number 1, you participate in a weekend rally protesting police brutality. Well, I know we don't have interactive right now, but that is perfectly legal, and you cannot be retaliated against or written up by your employer for going out protesting on the weekend. Police brutality, you name it, whatever rally you want to participate in, that's completely legal. We do have a case, I'll just share a little footnote, that we had a member not that long ago participate in an anti-immigration rally and was arrested for his participation in the rally. And he's on mugshots.com, and he did the right thing, and he told his administration what happened. And believe it or not, in his end of year TEACS evaluation, the principal wrote that it was unprofessional. And he contacted us, and yep, that stuff really happens, folks. That really happens. That it was unprofessional for him to participate in a lawful exercise of his free speech rights to protest government policies. And so he came to GAE, and we are going after this particular school district to vindicate his right to participate and free from retaliation from this particular school district. But yes, that actually happened. So number 2, you post on your Facebook wall a local newspaper article favoring a political candidate. Well, that's pretty benign, and yes, you can do that without fear of retaliation. I see no difference in this as to put the planting a yard sign in your yard. You can post an article from a local paper or your own political view, favorable or unfavorable for that matter, of a political candidate. And as long as we're talking as a citizen, a taxpayer, and a voter, you're protected, and a school district cannot retaliate. So 3, you write a letter to a publication that is critical of the school board, and I'm trying to move my screen. Whoop, pardon me. That is critical of the school board, I can't read that word.
For one of its actions.
I apologize. For one of its, okay, right. So there again, it's protected. You most certainly can, and we encourage you to write letters to local newspapers, obviously, or post on social media your views. But again, we want to be careful that we're couching them, that you're speaking as a citizen, taxpayer, and voter. You want to be sure that we're emphasizing those statuses when you do decide to speak, and we certainly encourage you and working through your local association. Perfectly legal. So number 4, you post a joke on Facebook that your students should be locked up. Well, has that ever happened? Well, yes, and so you know the result there. No, that's not funny. That's not a joke. That would be appreciated by the school district, the students, or their parents. So that could certainly lead to discipline by your employer. So that's not a wise use. As long as we're talking about Facebook, and I don't mean you can do this on the private side, but be sure you have Facebook on its highest privacy settings, okay? Not to say if you have the privacy settings at the highest level, you still don't want to say, express a view that your student should be locked up or things like that, because honestly, you don't know who your friends really are. You don't know if somebody wakes up one morning and doesn't like the way you didn't smile at them in the hallway or something like that, and they decide they're on your private side, and the next thing you know, what you posted on the private side is in the principal's office or the superintendent's office. So be careful with that. So you're instructed not to discuss with students your personal opinion on political matters, okay? So, okay, fine. So in a classroom discussion on racial issues in America, you tell your students that you have recently participated in a Black Lives Matter demonstration. So that becomes problematic because the school district has legal authority to control the course curriculum and teaching methods. And if somebody is specifically instructed not to discuss your personal political opinions in the classroom, then that could very well lead to discipline. It could be insubordinate. It could cause a disruption. You just open up a bit of a Pandora's box there. Now, on the other hand, and this is just on the other hand, some courts have looked at situations where the educator, there was no such instruction or policy not to discuss personal opinions in the classroom. So you could see a different result if there was no specific directive on that particular point. So I'll just leave it with that. But when somebody is on notice not to do it, it's best just simply to follow the directive. So we are looking to, so what's GA been doing to fight back? Basically GAE, and this is part of what we're selling for potential members, obviously, and current members, you should feel very confident that GAE has your back. Recently demonstrated in 2015 against Walker County, where the member wanted to express a viewpoint that contrary to the superintendent on the grading policy in Walker County. Well, he followed the public speaking policy, but he was still not allowed to get in front of the school board. And we were working behind the scenes, full disclosure, setting up the case to go into federal court. And the argument there was the school district's public participation policy gave way too much discretion to the superintendent there. It gave him way too much time and opportunity to censor a political point of view and keep that individual from getting to the school board, in front of the school board. And so we won a permanent injunction against Walker County for no longer utilizing the public participation policy that they had in effect in 2015. And I'm throwing in what the legal fees were in that case. Again, if it comes to, Mike, I don't have $330,000 to go into federal court, trial court, district appeal. We went to the 11th Circuit. You can see 3 years and a lot of money, but that's what we do. We take very seriously member free speech and association rights at GAE. And so that's a lesson for all of us. So that's kind of it for the slides. And we will turn it over, I believe, to Lisa for some additional questions that we had. I had an opportunity to research and try to get some answers to.
Okay. So the first question, stop sharing. The first question we have, and this is something that many people have asked about. So if I post on social media criticizing my school's reopening plan, can that come up in the school system once I report back to work?
Well, the lawyer's answer is it depends. And that is going to depend on a lot of facts and circumstances. It depends on the time and the place and the manner of your speech, as well as what's in your job description. Remember that Garcetti case said the public employee had a duty to, be critical and report illegalities in the police department. So we would have to look at those things, and we'd have to look at, well, did you use your status as a private citizen, voter, association member? Courts look at the content, the form, and the context in which your speech is made. So it's possible that you could be disciplined for being critical if your speech was during work hours. This is important to keep in mind. If you express your political views during work hours, that's just it's something that we want to avoid and not do. Now at work, this is not to say that you can't discuss the school's reopening plans and be critical of the reopening plans to your colleagues in the break room or in the hallways. Keeping it sort of low key, talking amongst yourselves. But you certainly have greater rights after school hours using your association status or as your status as taxpayer, voter, and citizen.
So what about my principal? Can I post post on Facebook saying something critical of my principal?
Of your principal. Well, no, that's something we don't want to do. As we talked about earlier, the case where educator goes into the principal's office and tears up the evaluation and walks out. And you certainly couldn't post that on social media because that's a personnel matter. That's only what Mike cares about. All the tax-paying citizens of DeKalb County really don't care much about what Mike's personnel evaluation is about. So it's not a matter of public concern. It's certainly a personnel and personal speech, which would not be protected under the First Amendment.
Okay, so I think I know the answer to this, but I'm going to ask it anyway because I've seen some of these posts and cringed.
Right.
So what if someone is posting about our parents or students?
Right. So it's really, I would say, not a good idea to do that. You don't want to criticize the parents because you know what's going to happen next. Parents going to pick up the phone and blow up the front office and central office. So if your speech is critical of internal school operations, and if you're critical of parent-teacher interactions regarding, instructional issues, like, for example, your child received an F because you lack parenting skills, you would not have a First Amendment protection for that type of speech, because it would be viewed as disruptive and you could be disciplined. On the other hand, there is room for discussing political views, and not to be critical of a parent, but we've seen chats and Facebook posts by members that are expressing political views that could include parents but don't directly involve parents. And I would just sort of leave it at that.
Okay. And our students, I don't think it would ever be a good idea to post something about our students that's not general.
Right. So yeah, the question that was posed, can I be disciplined for a post on social media about students? And if you remember the Atwater case, that was a middle school teacher, and she didn't name students, but she was highly critical, used derogatory terms to describe Black Lives Matter's protest marchers in her hometown. And that speech became highly disruptive to Tift County Middle School. So that didn't deserve free speech protection for that particular speech. So President Lisa is right. You're opening up a Pandora's box on that.
Okay, so we're gonna move away from social media with these next questions.
All right.
So, and this is something I've heard from quite a few of our members, that when they're in an IEP or a 504 or another meeting, they feel that they want to speak up and advocate on behalf of the students. I know a lot of times maybe the parent's not there to advocate for the students, so the teacher wants to do that. Can they do that legally?
Yes, and some would argue you have an obligation to point out when special needs children aren't receiving services, for example. Under federal law, this is not really off topic, but you also have rights against retaliation under the Americans with Disabilities Act for advocating on behalf of a disabled child. And there are also anti-retaliation provisions under IDEA as well, very important. And we also have a state whistleblower law that can come into the mix as well. And we've done this on a couple of occasions against, and I can name the system because it's a public decision, Valdosta City Schools, back in, the decision came out in 2014, but long story short, we had 2 GAE members who were special needs teachers in Valdosta City Schools at different elementary schools. And they came to us saying they were told not to report suspected child abuse and child neglect, okay? Not that they weren't receiving services, but it had to do with the way the children were coming to school. Some had fleas in their hair, some had torn clothing, some had distended, discolored bellies, showing signs of disease or malnutrition. And in both instances, the principals at these separate schools told both educators, I don't want to be bothered with this anymore. I don't want to be bothered with your reports because these are the kids from the projects. And that's just how it is. So they both came to us, GA members, and behind the scenes coached them how to set this up for a possible lawsuit against the district. And both of these cases lined up perfectly because before they were reporting suspected child abuse and were told not to do this, they were perfect. This was before TEACS, but they were like 4s across the board. In fact, one of the members has written a book on technology and special education. I mean, these are amazing, amazing teachers. But within weeks or a week of making these reports, where do you think their evaluations went? Down. And neither of these two teachers had any fair dismissal rights. So at the end of the year, the school district said, we're not renewing your contract and you have no rights to challenge. Well, GAE challenged in the federal court 2 separate lawsuits, were very successful in both accounts in, again, backing and supporting members' rights to advocate on behalf of special needs children. And you should know, and we'll be posting some of these answers later so you can get the site. But in both cases, the members won significant back pay. We were awarded all the attorney's fees. Again, in both cases, GA expended like between $70,000 and $75,000 on each case. We got it all back, and we got their personnel files expunged. So again, it's just an example, and I know I'm tooting legal services horn, but it's very important for you to know that GAE has a legal services program that has the resources and will absolutely go to bat in court when necessary.
This is something that's been happening more frequently with our high school students who want to exercise their First Amendment rights during school hours. How do I, as the educator, handle that? Can I encourage and promote them if they want to have a walkout?
Well, starting with a direct answer, no, you don't want to be in a position of advocating that your students conduct a walkout, for example. Why? Remember, it's going to be disruptive. Even if students have that right to do that, you don't want to be wrapped up in promoting that. You know, just like in some of the non-renewal or termination cases, you can't, once an educator is put out on leave, say for example, pending a termination, you can't talk to the students. That would be interfering or witness tampering. And so this is sort of the same thing. You're kind of, you don't want to be seen or perceived as inciting a walkout. So that's what we don't want to do.
So what can I do to advocate for better learning conditions for my students? Smaller class sizes, textbooks that aren't falling apart. How do I do that as an educator in Georgia?
Well, make sure you join GAE. That would be the first thing. The examples President Morgan gave, smaller class sizes, textbooks that aren't falling apart, up-to-date textbooks. Those are classic matters of public concern. Remember, you have strong rights to express your viewpoints on matters of public concern as a private citizen or speaking as an association member. And so these are right up our alley. And you know, I think another one of these Knights at Rights seminars are going to be touching upon what I said earlier, where school districts nowadays have waived class size limitations, for example. And we're receiving all kinds of horror stories where teachers are their class sizes are way up due to virtual learning and in-person learning. And, the class size limitations, quite frankly, they're not there like they were anymore. They just aren't. But the reason they're not there is based on who we elect, both at the State House and your local Board of Education can reform that, and they can reinstitute class size limitations. So those are classic examples where we should be speaking out about class size, textbooks, working conditions at the school, because those are matters that all tax-paying citizens of DeKalb County would want to know about, or wherever. So it's a good opportunity for us to be more robust in reclaiming our rights. We're going to have to.
Okay, so before I ask the next question, and somebody has asked a question related to this. So if you have a question and you are with us this evening, please send your questions through the chat to me, Lisa Morgan, and then I can ask them. And this is going back to our special needs students. And one of our participants asked, how do we handle a situation when you are emailed an IEP for a special needs student, but it was not discussed or clarified, and you are asked to digitally sign that document?
No, what you should do is put in writing exactly what you're being asked to do, because it sounds like it is potentially illegal. So before you follow that directive, I'd recommend that you email whoever sends you this email back and be very clear on what it is you're being asked to do, and express your opinion that it is potentially violates IDEA, ADA, and importantly, if we want a state whistleblower protection, then we need to find an exact school board policy that it is violating, and cite the policy in your reply email, or your email confirming what you understand this directive is directing you to do, and that your belief that it is violating the federal laws and even local board policy, and you should cite those in your reply. And then we kind of wait for the district to come back and see what the district is going to be willing to stand with that or not, or we get them to back down.
Okay, so this is a situation when, as a GAE member, we need GAE's legal help to deal with that situation.
Yes, okay. Yes.
Our next questions are dealing with issues that we are all confronting for the same time, for the first time, and that is virtual learning and privacy. So in some districts, students are being required to turn their cameras on during the synchronous discussion. So all the children are online like we are with this Zoom meeting, and instead of the cameras being off, everybody has to turn their camera on. What should the educator do if they see something in the background in one of their students' homes, which can happen? For example, an unsecured weapon. What should I do with that?
Right. So if you see an unsecured weapon in the background in your virtual classroom, you just have to, sometimes it's not easy, but you're going to you should report that through your local reporting policies. It's your classroom. What if you saw an unsecured weapon in in Lisa's kindergarten class, what would Lisa do? Well, she'd report that. So it's really incumbent upon us to report what could be dangerous to our students. You know, we are given rights to manage, control, and supervise our students. That is a tenet of education law. So applying it here, if we see an unsecured weapon in a virtual classroom, then you really should report that. And the only question would be, what happens if you don't? You know, what happens if you don't? So it's just better to be safer than sorry. And what's the other thing we do, GA members? We document. Make sure that your reporting is in writing, and these days it's all going to be by email. So, and keep a copy for yourself, whatever you send, remember. It belongs to the school district. If you're using the school district's email, that actually belongs to the school district, but you really should print out a copy of what you're reporting and keep it for safekeeping at home. It has been known to happen that emails disappear. That has been known to happen. School districts will go through and purge and delete, maybe through an automatic deletion policy. Sometimes it's not so innocent. And so in order to protect yourselves, keep a copy for yourself. Yeah.
Can I keep that copy digitally? So when I send the email, can I then forward it to my personal email account?
Yes. Yeah.
Okay.
That's a good process to use.
Okay. And so when I'm doing my virtual lesson and my children are all there, their microphones are on. And what happens when we hear the parents make a threat to a child, or their language is not appropriate for the classroom? Profanity. What do I do in that instance? Other than immediately mute that child's mic.
Mute. Well, what would you do if it happened in your classroom? Well,
I would ask the parent to leave the classroom, obviously.
okay, and you would report it
Right.
again. So it's the same idea as if it were to occur live and in person.
Okay, this is a question several people have asked us.
Okay.
What about privacy during virtual instruction? Not only we do have some districts that are saying for privacy reasons, they're not requiring students to turn their cameras on. But what about, how does the law for privacy impact that and their privacy for a recording during the virtual instruction?
Right. So there's no federal or state law that would prohibit recording digital instruction. And, in Georgia, under Georgia, we are what they call a one consent state, so that as long as you're a party to a conversation, you can record that conversation. So the same principle is going to apply in Georgia under state law. And then there's, of course, the Family Educational Rights and Privacy Act, which governs student privacy, but it's only going to apply either in a regular classroom or virtual classroom. Only if personally identifiable information is released without consent. However, there's a big exception that would permit disclosure of directory information without anybody's consent. And so directory information is the student's image, virtual instruction, that is directory information, or the school yearbook. That's can be disclosed and disseminated without anybody's consent. But things like the student's social security number, or the parent's social security number, or family members, personal data, date of birth, student ID, information that could lead somebody to identify a student. However, again, the exception would be capturing directory information like virtual instruction is legal. And so I think the way to sum up that question, it's new territory, but you should not share student information like grades that you wouldn't otherwise disclose during regular in-person classroom instruction. So if you have a good understanding of what not to share in class, regular in person, then follow the same rules for virtual classroom.
So we're going to go back to the political a little bit.
Okay.
So I know some teachers have done this with the virtual backgrounds that they've created for their classrooms, with particularly at this point, Black Lives Matter posters or a shirt. Can we wear that during virtual instruction or have that as part of our virtual background?
So yeah, I think we hit on that a little earlier. It's really that the district has the right to control course content, curriculum, and teaching methods. And I mean, again, the example we used earlier, if you're specifically told not to share your personal political beliefs and views in class, then you really shouldn't do that. So if you've been told not to do that, then you shouldn't have those in your Zoom background or be wearing a Black Lives Matter t-shirt that could be construed as insubordination and substantially and materially deviating from course curriculum. So that could particularly lead to discipline.
And the last question I'm going to ask this evening, because our hour is almost up, is from one of our participants. And it is about the virtual instruction and the cameras. Can the district legally require students to turn on their camera during virtual instruction?
That's a good question. Can they? I guess the question would be, what happens if they don't? And that would be a matter of student discipline and following the student discipline procedures. If they don't, or if they refuse, to not turn on the camera. I mean, I would be suspicious. Why? What's happening at home? Do we have to call DFACS? I mean, what do we have to do? Are there unsecured weapons everywhere? I mean, there's a whole lot of reasons. So, I mean, I would say if they're not turning it on in violation of a school policy, then the school district's just going to have to deal with it. Yep.
Great. Thank you for all the great information, answering all our questions this evening for our members. And thank you to our members who have joined us this evening. Our next session will be September 29th. And on September 29th, we will be talking about teacher keys, the Great Integrity Act, and more about student discipline. And if you want to register for that now, go to the GAE website, log in to the website using your email and your password, then click Issues and Action, the Legislative Action Center, and then Rights at Night. It's the very first one. Thank you for joining us this evening. We will be doing our regular Facebook Live on Wednesdays, except for those weeks that we do Rights at Night, and we have those scheduled. You can see all the topics up through the month of February on the website, and be looking for your No magazine to arrive in your mailbox soon. And please keep in touch. Let us know how we're doing, and also talk to your colleagues and let them know that GAE is advocating for you on the front lines. Thank you for being a member of GAE. Thank you for all you do for our students every day, and have a great evening.